Hello, everyone. Welcome to the first AI Talk at ETUI of 2025. My name is Aida Ponce del Castillo, a senior researcher here at ETUI, following very closely the AI Act and all things AI, and I will be your host today. Today we have a special guest, Dr. Laura Caroli, and she is now at the US working as a senior fellow on AI governance and regulation at the Wadhwani AI Center at the Center for Strategic and International Studies in Washington, D.C. But previously, Laura had a very interesting job. She served as a senior policy advisor to the MEP Brando Benifei at the European Parliament from 2014 to 2024. And on his behalf, she has led negotiations on the EU AI Act at the very technical level. And she also has experience in internal market on AI, digital affairs, as well as foreign affairs, defense, and human rights. Previously, Laura worked at the Intelligence Foresight Committee at the Italian Parliament for the Italian think tank Italianieuropei in Rome. Laura holds a PhD in Geopolitics from the University of Trieste, and today she's about AI, the AI Act, and all the transatlantic developments and how they are impacting AI safety. Laura, please, the floor is yours.
Thank you so much, Aida. Thank you for having me. It's a pleasure that we finally managed to have this talk. We have tried for several months. Do you hear me well, first of all? Okay, great. Thank you, and hello, everyone. Yes, so I moved here in October, just before the American presidential elections. So I have had the privilege to observe these very interesting developments from a very close distance. And I have learned since I came here a few things about the US and their policies on AI. Well, not that they were not known before, but of course, being here makes everything clearer. Something that we don't know that clearly is that, and that I repeat to everyone here in the US when they say that Europe is the regulator and the US is the innovator, is that actually the US also regulated AI to actually a very strong, substantial extent in some cases, especially with the help of the Biden administration and its policies. In particular, with the executive order of last year, end of 2023, and subsequent actions, you can see a strong attention of the Biden administration on fundamental rights and on making sure that federal agencies really incorporated at least strong risk management policies to prevent bias and disproportionate impacts on fundamental rights in areas that are very similar to the ones indicated by the AI Act as high risk. For example, one example is if you take a look at the OMB memorandum at the end, published at the end of March of 2024, further detailing what agencies needed to do. There is a section detailing a list basically of purposes that are presumed to be rights impacting. So what would more or less amount to Annex 3 of the AI Act. And there are some very, very similar areas, such as law enforcement, emotion recognition, education, public housing. Since we are here with ETUI, I will mention also determining the terms or conditions of employment. So the workplace is also one that includes also conducting workplace surveillance or automated personnel management. So it has a very, very detailed section on workplace impacts. And at the same time, going even further than that, the National Security Memorandum that was put forward by the Biden administration at the end of October, so just a few months ago, contained a lot of, innovation-friendly policies, some action for massive energy build-up to support AI development, but at the same time, it introduced prohibitions. One thing that might sound strange for federal agencies to use AI in certain contexts. For example, these prohibitions sometimes even go further than the AI Act. In especially two cases that I was very, very surprised to learn. One is the fact of using an AI system to make a final determination on the migration status of an individual. So whether it is asylum or admission into the United States. This actually is the National Security Memorandum, so it applies to national security related departments, federal agencies and departments. For example, the Department of Homeland Security, so the one that actually gives determinations on migration status. Let's recall that the AI Act does not prohibit the use of AI systems to determine the migration status of a person, but only places this type of systems as high risk, so in the high risk section in Annex 3. So in this case, the US were going further than the AI Act. There is also much more detail in the prohibition of biometric categorization. That was a controversial one in the EU AI Act because some said that the categories were not complete, that they were a bit prone to loopholes, etc., etc. Whereas in the National Security Memorandum, it's very complete. For example, it also includes gender identity. That was seen by the member states in the European one as very dangerous, for example, by Hungary, countries that are not super happy about emphasizing the gender aspects of a person's identity. So I think these are very, very interesting developments, and unfortunately, so this is to say that basically the US and the EU were becoming very, very close in protecting fundamental rights in EU legislation. Unfortunately, then the presidential elections happened, and one of the first actions of President Trump was to repeal the executive order and to order a review of the National Security Memorandum. This will mean that basically all the policies that I just described to you will be scraped away. At the same time, let's not forget that state legislation also exists in the US. The clearest example, because it was the first, is the Colorado AI bill. I don't know if any of you has ever taken a look at this law. It's actually not very long, so it's like 30 pages long. Unlike the AI Act, which is 450 pages. But actually, it replicates a lot of the reasoning of the AI Act in the high-risk classification, the responsibilities of providers and deployers, the impact assessments that one has to perform, and again, the identification of the high-risk areas in which employment is one of the key ones. So again, these state-level pieces of legislation will stay. It is unclear whether or not there will be any federal action. They have tried for years to have a federal law in place on AI, but without much success. At the same time, we are now in an era where the concept of, AI risks, AI safety in general, seems to be really not trendy anymore. Everybody's focusing only on the opportunities, on innovation, et cetera. Trump's first executive order on AI is all about innovation, doesn't contain any policy whatsoever to mitigate risks. Even speaking to some people close to the Trump administration before they came into power, they were even speaking of the concept of AI safety as something very politicized and weaponized. By the very polarized Congress. So they said at that time that instead of talking about AI safety, we could only speak about guardrails, because, yeah, of course, they do recognize that some guardrails are necessary, but you cannot say AI safety, because otherwise they will not listen to you. They will think you are a woke politician, etc. So it has become very difficult to have this debate right now. Even at the international level, we know that in Europe, with this renewed focus on competitiveness at all costs, one might think that even the enforcement of the AI Act might actually at some point become quite weak because of this, because of the need to really boost the EU's competitiveness. Now with the competitiveness compact, there are a lot of there are a lot of actions on AI. Commissioner Virkkunen said just a few days ago that the EU must become the AI continent. It remains to be seen, because we are lagging behind quite a lot on that in that regard. But also at the international level, the issue of safety seems to have been sidelined a little bit. If we think that, for example, the International Summit on AI safety that became famous, last year, the London UK Safety Summit, and then the Seoul one. Now the Paris one that will take place, it's actually already taking place with its side events, but will be in the official program next week. It's called AI Action Summit, and the focus on safety is only a part of it. There is a lot of focus, for example, on creativity, on innovation, and the likes. At the same time, even in the UK, I've participated in a debate just a few days ago on in a UK-based think tank where they were discussing really exactly this. Like, we don't talk anymore about AI safety. It's not trendy anymore. Even the UK government, one would think, the Labour government would focus on much more than the conservative ones on AI safety, on AI risks. It even promised to have a bill on AI safety, at least for frontier AI models. But for the time being, they are still working on that. Apparently, it has a bit disappeared from the headlines. What we have seen so far at the beginning of the year was this very broad action plan by the Starmer's government that actually contains very, very little on AI safety. If you just search for the word, you will only find it twice in, I don't know, 150 pages or something. So it seems to have become a little less important. At the same time, I think it's interesting to note that with the advent of DeepSeek R1, suddenly the Western world has become again a bit more attentive to safety, because it has become clear from first model evaluations that have been done by external researchers, that DeepSeek doesn't respect a lot of safety benchmarks and even security benchmarks. So it has a lot of vulnerabilities. At the same time, in Europe, it has become quite clear very fast that it doesn't comply with GDPR at all, like really at all. So basically, virtually all the, at least Central Western Europe's data protection authorities all have requested further information. The Italian Garante has already blocked access to DeepSeek in Italy. I think this will also happen more broadly in the rest of Europe, probably in the upcoming weeks. Let's see what happens. At the same time, it does present a very big opportunity for AI startups in Europe, because it shows how possible it is to actually make very big leaps of innovation without the cost of the big models and without the compute needed to train large-scale AI models. But again, not by bypassing all basic guardrails that we have in place. Let's not forget that at the same time as we speak, the EU is in process of, drafting the famous codes of practice for general purpose AI models. I am trying to understand just this couple of days that just went by, whether or not DeepSeek will have to comply with the AI Act. It is not exactly straightforward, because one first needs to understand what DeepSeek is according to the AI Act. But for sure, it will be one of the issues that will be very much debated in the upcoming weeks, because it has very big implications of on not only on EU innovation, but also on the safety of our consumers, workers, individuals in general in Europe, because of course, when a model is not safe and it's replicated, it's fine-tuned into applications, it has thousands of possible harmful uses. So I think I'm almost 20 minutes. So Aida, what do you say? I
have a couple of questions for you, Laura. Thank you for this very overarching, interesting points and points of information and reflection. But first of all, before we open the room for our audience, and this is a shout out to all of you, please write the questions in the Q&A, because then we can have a more fluid conversation with Laura here. So my first question to you, Laura, to warm up the Q&A would be, we have now the article number 2 of the AI Act we have entered into force a couple of days ago, the article that lists the prohibitions. And of course, this will be accompanied with some guidance documents by the European Commission. So what are your expectations or your gut feeling about the line that the guidelines will take on the one hand, and on the other hand, who will enforce these prohibitions at the national level?
Okay, that's an important, very important, and also tricky question, especially the second one. The first one, everybody is now expecting, like, refreshing their screens to see if these famous guidelines on the prohibitions have been published. No sign of them yet. I mean, a few months ago, when in September or something, everybody was already asking the Commission to in public events when they would publish these guidelines. And I said, given the change of the term, so the appointment of the new Commission, it would depend on when the new Commission's mandate would start. And since it started rather late, compared to other times in the past, this would require some, internal rearrangements for internal processes and all. So it delayed a bit, I guess, the publication of these draft guidelines that were no, it wasn't exactly draft guidelines. It was this draft consultation that was put in place by the Commission, where stakeholders were invited to intervene and make their points heard. I have in particular a hope that 2 specific points will be taken into consideration by the Commission very seriously. First of all, is the issue of emotion recognition at the workplace. I would hope that the guidelines finally explain whether or not this prohibition also applies to the recruitment phase. So during interviews, job interviews, we have heard several times how this confusion on whether or not this would apply has an impact on potential employees, potential workers, and can be particularly harmful. I mean, at that time, I was also hoping to actually expand in the high-risk AI use cases, not the section to make sure that not only also in the education area, not only they would apply to proper education, so school, but also competitions for example, for the EU institutions, that there is this EPSO procedure whereby you have to use a computer and a screen, and if you even so much as move your eyes from the screen, sometimes you get disqualified because it would appear as if you are taking, suggestions from someone, or you're reading something from a book to help you. So this is particularly harmful for individuals. And imagine in the broader area of workplace applications, how it is important that we clarify this. So the second point to clarify for me, on which I have been speaking to several civil society organizations to make sure they also took action. We have coordinated a bit so that this point really is clarified, is on biometric categorization. The way it is written right now in Article 5 seems to hint to some to an exemption for law enforcement, but it's not true. In the intentions of the negotiators, like I can tell you because I was there in the room, biometric categorization was very difficult to negotiate because member states at the beginning thought that it was a proposal by the parliament, and the member states were convinced that we were trying to prohibit the possibility to search in a database according to specific categories. So imagine an Excel spreadsheet where you normally can search for category, like all the people living in Brussels, for example. They are all in the same column. You search by column, and that gives you a list of people. So they thought that we wanted to eliminate this possibility. This would be particularly detrimental for law enforcement. For example, when they want to see all in a list of suspects, they want to see all the, I'm sorry I have to say this because it pains me to say so, but for them it would be helpful to see all the Muslim ones, for example. Of course, we resisted that that concept, but also we tried to explain that what we meant was actually the possibility for an AI system to infer based on your biometric data whether or not you were pertaining to a specific category of people related to sensitive data. So whether or not you were a right-wing person, whether or not you were Muslim or Jewish, or whether or not you were gay or straight. So of course we can imagine the very, very dangerous impacts that abusing this kind of use can have in the wrong hands, and so we made sure this was prohibited, but then the council wanted us to add the sentence that is just attached to the same prohibition, saying that this does not mean that law enforcement cannot use a lawfully acquired data set, and search through it as much as anyone else. Anyone can search through a data set, basically. This is not prohibited. But the fact of placing law enforcement there relieved at that time member states from taking, the final decision on the AI Act. It was one of the points where they were the most attentive on, unfortunately. So I hope that the guidelines clarify these two aspects, and also as for the enforcement of the prohibitions, I've seen several lawyers already hinting to the fact that even though the real enforcement of the AI Act will start from next year, so when the high-risk cases will start applying from August 2026, which is also when basically all the authorities will be in place, because member states in some cases still need time to appoint their authorities. There are internal processes that are long, and they have to restructure even existing ones to make sure that they have the necessary competencies. But at the same time, there is apparently a safety net through the GDPR, because GDPR states that data protection authorities can enforce the rules on practices that are unlawful, and therefore, since now they are unlawful, the use of AI systems in the prohibited practices, GDPR can also apply to this. I will also make an addition to this interpretation, which is that for all the cases involving law enforcement in the prohibitions, and there are many that involve law enforcement, many very delicate ones that we just mentioned, law enforcement will be supervised by the Data Protection Authority through the AI Act. So in this case, there is no need to appoint a specific authority. The AI Act already states that law enforcement needs to be supervised by default by the Data Protection Authority or a similarly appointed authority. This was one of the wins of the Parliament during the last very long trialogue, and it was to make sure that at least there was some guardrail to the powers of law enforcement authorities that the member states wanted to expand as much as possible. So we kind of counterbalance that with direct action from an independent body such as the Data Protection Authority. So indeed, there is a strong role to be played by the data protection authorities immediately. So this would be my interpretation.
Thank you, Laura. I will start taking questions from the chat, and please don't hesitate to write them down. Because we're talking about GDPR, I'll take a question from Nicolau here, and he says, if we are speaking about GDPR violation, we do not need guidelines but legislation. And a similar comment is, are there any plans to have an EU legislation directive maybe to ensure a minimum respect of the GDPR? Even GDPR is not respecting GDPR. Well, I don't know if we can make some sense about it. But...
Okay, I'm not sure exactly what Nicolaus means by guidelines. We do not need guidelines but legislation. Are we speaking about the guidelines that I mentioned on prohibitions?
Maybe there is a confusion there. Probably.
Yeah,
if he wants
because the guidelines are on the AI Act, not on GDPR. So, and well, on the legislation to apply GDPR, there has been well, I don't know if negotiations have been completed on this, but there was a specific targeted action on GDPR enforcement. I haven't followed them, but because I was not part of the Libe committee, but I have colleagues who were directly involved in these negotiations. I can redirect you to them. I don't want to say false things, but this is only about enforcement, because GDPR has had some issues with coordination of authorities at the beginning. So it's not about the rest. Like, the principles still apply, and GDPR will not be reopened any soon. Even the Commission seems to agree with this, and it would be very dangerous to reopen it, frankly, especially now with this new majority in Parliament.
Right. So let's go back to the EU-US now that you are in the other side of the Atlantic, and we have a burning question here. From Paul McKenna, how much will Trump and other leaders let Musk and others, I suppose tech companies, control or influence AI if they see it is a concern on cost to companies on AI safety? I agree on AI in the UK, but trade unions should push the agenda. What is your view here?
So indeed, this has been one of the points that have been the focus of a lot of thinking here by experts. First of all the experts seem to agree on the fact that Trump is unpredictable. So it's not exactly 100% sure that he would behave a certain way. And in the case of AI, of course, it will be very important to see how much Elon Musk has direct influence on AI policies. Because actually, Elon Musk, let's not forget that he was always very vocal about the need to have very strong AI safety policies in place. One also interesting fact that I like to mention to American companies that criticize the AI Act for being over-regulating is that you will recall the California AI safety bill that was approved in September. It had a very broad majority. Unfortunately, it was vetoed by the California governor. The point is that when I read that bill, I actually thought, wow, it went much further than the AI Act in mandating safety measures for frontier AI model providers. Actually, Musk was a supporter of this bill, together with Future of Life Institute, very vocal on this, and others. Now, as to the reason why Musk is so adamant about the need to, you will remember last year's call to stop AI development for 6 months, for regulation to catch up. I think that it is also a matter of personal competition with some specific actors in the tech space, namely OpenAI. Like he really doesn't appreciate the turn that OpenAI did towards a fully fledged company, and it, from the first goal to just advance AI for as a non-profit, as a research endeavor that he contributed to fund. So it will be interesting to see who will influence AI policies, because the majority of the Trump supporters, influential people in his administration, are actually very pro-innovation. As I was saying, only optimistic views, only some very light guardrails, but they don't mention exactly what. Whereas at the same time, we have Elon Musk being so vocal on AI safety. I also have to say that it's been a while since I've heard Elon Musk mention AI safety, so I don't know what happened to this. And we have seen already some cracks in his close relationship with Trump when he criticized the Stargate initiative that, of course, saw again OpenAI as one of the prominent protagonists. So it would be very interesting to follow this in the upcoming months.
Laura, just as we speak,
Sorry.
I think that awaited guidelines are already out.
Yes.
So if,
Yes, someone just sent me the link.
me too.
Okay, let's check them together. I don't know.
So we have the guidelines, 140 pages
Oh my God.
available. So we will have time to go through them and maybe do another AI talk to speak about the guidelines.
Yeah.
Well, we don't have the time to discuss them now, but they are out finally. Let's go through another question. And yes, the question about the guidelines that Nicolao asked before, was, yes, about the AI guidelines, because I think that he says that they
Yes.
are not mandatory.
Yes, guidelines are not mandatory. They are indeed just they just help the interpretation of the regulation for companies and actors in general involved. But these were mandated by the AI Act. And if we think that everything will need to be implemented by further legislation, then it will be very, very hard.
Laura, do you feel comfortable to speak about the chapter of algorithmic management in the Platform Work Directive?
I mean, I'm not an expert in the Platform Workers Directive, but what
There
does this
is a question
say?
from Anna Hampel saying, do you see an effective transfer into national law enforcement of algorithmic management section of this Platform Work Directive in danger at the moment?
I don't know if I understand the question because they are quite separate issues. Why would it be in danger, first of all? Second of all, it's a directive. It's not a regulation, so it doesn't apply directly like the AI Act. So it will need to be transposed by national legislation. And I'm not sure whether this, I suppose this will take a few months. Like I think normally it's a couple of years that they give member states to transpose the directives into national legislation. So it's a bit early to say, and I don't think that provisions on the AI Act can put it in danger. Actually, we also made clear in the AI Act that the Platform Workers Directive will still apply in its own right. So, the AI Act application cannot be construed as trumping over the Platform Workers Directive in that specific context. We also made sure that there was a space in Article 2 for the further specification of workers' rights related in legislative initiatives at the EU and at national level at the same time. As S&D, the S&D political group has always advocated, like for years now, for a specific legislative initiative on AI at the workplace. This was also, this became a call of the whole parliament, because we managed to put this also in the final report of the AIDA committee. Nice choice of word, like your name, AIDA. The AIDA committee was the special committee on AI that the parliament created before it worked on the AI Act, on which Brando Benifei, so my former boss, was also one of the shadow rapporteurs. So I also participated in the negotiations of the final report. That was a very, very long text, and among several actions proposed, we also asked for this directive. And I think that in Parliament there are now there is now action to produce a legislative initiative report to ask to concretely ask the Commission to produce a proposal for a directive on AI at the workplace, because they seem to have forgotten this a little bit. But I know that our people in Parliament will insist in the upcoming months.
Okay, interesting to hear that, because I have also heard rumors that that legislative initiative will not take place, or that there is not enough willingness from some people in the EU institutions to take this over. But your gut feeling
Maybe Commission, but the Parliament still
has it.
remembers that.
All
The
right.
problem is also that the new majority in Parliament might be tricky, because it's not the same as it was anymore, you know. So it's much more liberal now. So it can have negative repercussions on the content of these reports, for example.
Mm-hmm. And what could be those negative repercussions?
Like, it can be a bit less protective of workers and a bit more attentive to companies' needs, you know, which is worrying, because of course we are talking about a major imbalance of power. So we cannot treat companies and employees on the same level.
Right. We have another question here.
Yes.
We'll read it out loud for everybody. Companies are forcing to use AI for occupational health and safety inspection. From a trade union perspective, says Nicolaus, what should we worry about?
Well, can you make an example of how AI is used for occupational health and safety inspections?
Well, I would perhaps say that this might not be the case everywhere in Europe, but because labor inspector or inspections in national levels, they do not have a lot of means and tools to inspect workplaces using AI. So I would challenge this statement by Nicolau, and this is the labor inspector is a little bit lacking resources at the moment. And yes, cameras to inspect about personal protective equipment. So I don't know, Laura, if you have something to say.
This actually reminds me of one of the debates we had at the conclusion of our negotiations about, for example, again, emotion recognition at the workplace. What does it actually mean? Because there is this exception for, not exception, but specification that physical states do not amount to emotions. It's specified in the recitals. Because council really wanted to make sure that the safety of, for example, the clear example is truck drivers could still exactly be protected from falling asleep through impulses by AI that would detect people falling asleep. At the same time, they also at some point wanted to include the fact of being able to detect the level of stress and anxiety of a worker, because it could be helpful, for example, in suicide prevention hotlines. Imagine a case where an operator trying to talk to a suicidal person, after talking to suicidal people all day long, might become negative in their tone of voice, or stressed, because of course these are not easy conversations to have, and it actually would be detrimental to the person they are talking to, because it would actually help them much less and actually encourage them even more to commit suicide, so they claim that in these cases it could be helpful, but then it would open the door to too many loopholes, because exactly through facial recognition, emotion recognition. Again, emotion recognition is not a straightforward concept. Like people express emotions in a very different way, not only from one individual to another, but also from one culture to another. So people from a different ethnic background might not exactly match the expectations of an AI emotion recognition system that is, for example, trained on white people's biometric data. Or by the way, the Commission itself recognized, even in the impact assessment to the AI Act, that emotion recognition does not have a clear scientific base. So even the concept itself, that is why the Parliament wanted a much broader ban than this, but this is what we could obtain. I'm sorry. What was I saying? That emotion. And also imagine also people with a certain disability might express emotions in a very different way. So it's the result of a lot of factors that and context that an AI cannot be well placed to understand. And so it can be very, very detrimental. Even like, of course, a worker might be stressed. I mean, they are at work. I'm also stressed right now, for example, but it doesn't mean I'm not enjoying myself talking to you, or that I don't like my job. Maybe I just want to do it right. So there are so many factors in the mind of a worker and its will and performance at the workplace. Some people perform better under stress. So it's really, the concept itself is not leading to any beneficial outcomes, in my personal opinion, and also in the opinions of several of our colleagues when we were negotiating.
Maybe a last question, Laura, and coming back to GDPR and enforcement of AI and the AI Act and the GDPR, there's a question about the Dimitri Krikalier about the enforcement authorities, and I think that he refers to the European Data Protection Supervisor as an extension of the European Data Protection Supervisor question. Is there a requirement to set up local agencies to control the AI Act implementation in the countries? I think that there is a clarification to be done of who is going to be the enforcement authority at the national level.
So yes, one little problem that we have with the AI Act, and it's not because of the Parliament, but because of the Council, let me be very clear, is that the AI Act does not establish a specific authority, does not designate a specific authority like GDPR does. So there will not be an AI authority in the member states, but each member state will be able, will have the right to appoint whatever authority they want as a market surveillance authority, because again, the AI Act is a product safety piece of legislation. And so it hinges the enforcement to the market surveillance regulation. That gives very substantial powers to the authorities, so even more than GDPR to some extent. But having said that, as I said, for law enforcement, migration, and the judiciary, the authority will be the Data Protection Authority by default. As for the others, the supervision of companies and other public authorities, it would be up to the member states to decide. And now we have a situation of very diverse authorities being appointed. For example, Spain created its own agency that is not exactly independent, but at least it's very far away. So it's physically very distant from the government. Whereas, for example, the Italian one, it's actually a double agency that will take charge of enforcement, and they are both under the direct control of the Prime Minister, so it's not independent at all. At the same time, Luxembourg appointed the Data Protection Authority. I think the Netherlands will also do that. Germany is very likely to appoint, apparently, the telecom authority. So as you can see, it will be a patchwork of different authorities speaking different languages, because they will be expert in very different things. So we will see how it goes, if coordination works well within the AI board at EU level. There are mechanisms to ensure consistency, so let's hope it works.
Thank you, Laura. There is again another question about a new data protection officer at the EU, but I think Clara Fritsch refers to the new data protection supervisor at the EU. It has not yet been appointed, but if you can say something about that, Laura, Caroli, that will be interesting for Clara.
The supervisor, yeah, well, it's not in my remit, but indeed I've heard all about this election that saw a different result in Parliament compared to Council. So the Council backed the current data protection supervisor, Vjevorovich, whereas the Parliament actually supported the Italian member of the Commission, so DG Just. And unfortunately, this creates a bit of an institutional problem that will be solved. I think it hasn't been solved yet.
No, there were some hearings last week,
yeah,
and the institutions are still thinking about who is the best
great
candidate to sit on that very important supervisory office.
Of course, the whole point why this whole thing is problematic is because appointing an official of the Commission to become the EU data protection supervisor can be construed as the DPS losing its independence, because if the member of the Commission actually continues its ties with the Commission, passing information, etc., or receiving, advice on how to act, might hinder the very important need to maintain independence, since the EDPS will, apart from enforcing compliance with GDPR, will also enforce the AI Act compliance by the EU institutions. And let's think, for example, about Frontex using biometric recognition systems that we will not be able to use anymore. So it will have to be very strong in enforcing the prohibitions. So it needs to be independent.
Yes, and with that, Laura, Caroli, if you would like to close this webinar with one hope or expectation for the next months, what would that be?
I think that we will see from next week AI summit with, again, this advent of DeepSeek, that the discourse on AI safety and on fundamental rights is not dead, and it needs not to be dead. And the EU is very well placed now because it has all the guardrails in place to actually enable responsible innovation by EU companies. And so I think this will be very beneficial, not only for companies, but especially for citizens and individuals. And this is why we have these rules in place. So we should not be shy about them.
Thank you very much, Laura. And that brings us to the end of today's AI talk. A hearty thanks to our guest, Laura Caroli from Washington, for being with us. And to you, the audience, we hope that you have found today's episodes interesting. Thank you for turning into our AI talks at ETUI. See you next time, and goodbye.
Thank you so much. Thank you, everybody. Thank you, Aida. Bye-bye.